Hello, everyone, and welcome to FISD's webinar from the Alternative Data Council on defining ethical behavior and web data collection. We're delighted you could join us. I'm Tracy Shumpert. I am the Vice President of Membership and Programs here at FISD, and I'm going to go through just some basic housekeeping and then give you a little overview about the Alternative Data Council's activities. So firstly, I'd love to thank our global sponsors, SIBO, CME Group, FactSet, and SIX, as well as our featured sponsor, S&P Global Market Intelligence. And I'd like to remind you, our organization, like many of yours, has an antitrust compliance policy. I don't expect this will be a problem, but please do not collude. I'd also like to let everyone know that this event is this webinar is entirely off the record. Please don't record it. If you want to quote any of our wonderful speakers, please reach out to me and I will put you in touch for permission. I'd also like to thank FISD's new members, many of whom are involved in the Alternative Data Council, ThinkNem, Exabel, Luminati, and S4 Market Data. If you meet any of them online, please say hi. Thank you. Also, if you'd like to engage with us on social media, you could do so in any of the ways listed below. Many companies' spam filters are increasingly sophisticated, and we want to make sure that you know about upcoming activities like these. So as I mentioned, I'm just going to give you a little bit of an overview about our activities on the Alternative Data Council before I turn it over to the panel. So firstly, really what's the goal of the Alternative Data Council? Ultimately, it comes down to getting data to flow. So the Alternative Data Council was created about 2 years ago with a goal of lowering costs for the benefit of end clients. And really, who's the end client? My beloved collaborator, colleague, Norma Niemer from UBS Asset Management, always speaks to those end users really as the firemen and teachers and all of us who have investments really are benefiting from lowering costs. Of course, we also want to facilitate the growth of the industry and drive the adoption of alternative data in the investment process. And as we'll discuss later today, of course, also promote the ethical use of data. Who's involved in the Alternative Data Council? We have over 30 buy-side members representing over 10 trillion in assets under management, over 20 vendors and over 5 data sourcing platforms. In truth, these numbers are low because we keep having people join virtually every week, and we haven't updated these numbers for a little while. So it's a growing group. If anyone who is listening would like to participate in the Alternative Data Council, please shoot me a message. So what does the Alternative Data Council do? We create standards to facilitate everything that I just mentioned. And we have a ton of stuff that is published and a ton of stuff that's coming out. So just to go over that briefly, right now, if you Google Alternative Data Council, you'll come to the page and you can right now download and use a data vendor tear sheet, a compliance due diligence questionnaire, a data buyer checklist. We have a number of web data collection considerations already published. We'll talk more about those later. A standardized trial agreement and an overview, a guide to alternative data, which we colloquially call the buy-side guide. We have a ton of stuff happening. So right now, the data engineers in the group are working on a data information package. Soon we will turn our task to REST API standards. We have a number of web data collection considerations coming out. Again, we'll talk about those in a minute. And we're also working on best practices in communications between vendors and customer firms. So specifically with respect to web data collection, we have a number of considerations that are on the website. We call them considerations on purpose, and we may get into that a bit later. So the topics already published are terms of service, proxies, volume, robots TXT, copyright and privacy. And then right now we're working on CAPTCHA, cease and desist, and do not compete. Once we get through those, we're going to reevaluate how much more territory there may be to cover. That's sort of what's in the queue right now. Now, I would love to turn it over to Elizabeth Pritchard, who is going to be our moderator and the panelists. I'll see you guys at the end.
Thank you, Tracy. Hello, everyone, and thank you for joining today. We're going to discuss a very important and at the same time complicated topic. Simply put, web data collection is a popular method, as Tracy mentioned, for gathering information about companies and products and other entities from the internet to inform decision making. It is also one of the least clearly regulated areas. Joining us today, we're really fortunate to have a panel of experts to help us understand and navigate this evolving area in the law that can pose some challenges when determining the compliance risks of your web scraping projects. It's my pleasure to introduce from the buy side, joining us, Max Aben, Vice President at PDT Partners, and Danny West, Vice President and Senior Counsel at Two Sigma. And presenting views from web data collection providers, we are fortunate to have Sarah McKenna, CEO of Sequentum, joining us. You should know that each of our speakers today have been tirelessly working for the benefit of the industry at the Alternative Data Council. They have been working with many firms to clarify the considerations for web scraping, while at the same time working more than full-time jobs at their respective firms. Thank you for your efforts. Okay, to get going in our conversation today, let's take a moment and gather some data from the audience by starting off with a quick poll. Does your firm prefer to create your own web scrape data sets in-house, license web scrape data sets from data vendors, do some of both, or you don't use web scrape data at all? So let's just have you take a minute and answer the poll. And as Tracy said, web scrape data is the most popular type of alternative data in the industry. Curious to see the makeup of the audience today. Okay, just take a moment to answer and we'll wrap up by, let's take a look at the results. So, okay, so not surprising, the folks in the audience do some of both. So you're licensing data vendors and your engineers are having a hand at going out and creating bespoke data sets, followed by we don't use web scrape data. So panelists, I'd ask that you keep that in mind as we go forward to start exploring the topics. Now we're going to turn over to Max and Danny to address why it's important to have an industry view on this topic and explore the legal landscape. Over to you, Danny.
Thanks, Elizabeth. And good morning, everyone. Thanks for joining us today as we discuss web scraping standards and considerations. Before we dive into the substance of today's discussion, I think it's really important for the audience to understand the different risks that buy-side legal and compliance professionals really focus on. Now, for many buy-side firms, the legal and compliance teams are the gatekeepers that can determine whether a firm is able to purchase and use a specific data set. And if a data set presents any of the risks that we're about to discuss, it's going to be an uphill battle, if not impossible, for the legal and compliance team to sign off on the purchase of a data set or the trial of a data set, whatever the case may be. Therefore, I really think it's paramount that data providers understand the nuances of this risk and how buy-side legal and compliance professionals look at them and design their products accordingly. Not only do I think that it'll reduce risk that the data providers face themselves, but it's really going to make for a smoother adoption on the buy side. So it's going to be a win-win. So with that said, let's dive into these. First things first is insider trading. So of course, this probably comes as no surprise. Preventing insider trading or even the appearance of insider trading is going to be the buy side's primary goal. We're going to get into this on the next slide in more detail, but in order for the SEC to bring an insider trading claim, they're going to need to prove three elements. So all three of these elements are going to need to be present. First, the information needs to be material. Second, it needs to be non-public. And third, it needs to be obtained in a breach of duty or trust. Like I said, on the next slide, I'm going to go into these in greater detail. But the thing that Max and I really try to do when we have calls with data providers and we go through all these diligence conversations and diligence documents, the goal of those conversations is to knock out at least one of these elements or show that one of these elements is not present and document that so that when the SEC comes knocking on our door, we can show, hey, this is not MNPI because one of these three elements isn't present. Moving on to reputational harm. So reputational harm, at least in my mind, is really closely intertwined with data ethics. In that even if a data set or data provider is collecting the data and it doesn't violate the law per se, if the collection or distribution methodology that's being used is unethical or deceptive, it still is going to present this reputational risk that could result in large commercial harm to a firm. We're going to provide a few examples of this reputational harm and how it can manifest itself later on in the presentation. But I think a good way to think about reputational risk, if it's not obvious to the audience already, are the resulting business consequences that could arise from negative media coverage. Some of these, I think the worst consequence that could happen on the business side, at least for buy-side institutions, is investor redemptions. So if there's a negative news article that really makes them uncomfortable, they can redeem their investments with us. So that's reputational harm. Moving on to general regulatory. So this is pretty interesting. I think that many of you are aware that the SEC has announced that alternative data sourcing, diligence, and usage is going to be one of their priorities this year when they examine firms like Maximind. As such, I think a lot of the buy side expects to face questions related to its data onboarding and diligence practices. And what we're really going to need to do is demonstrate that we have policies, processes, and controls that are consistent and effective in keeping in line with industry norms. So as Elizabeth and Tracy were saying, part of the reason that the Alternative Data Council was formed was to establish baseline web scraping industry norms, because there just weren't that many. I mean, we all kind of know these topics, but how they were interpreted and enforced were a little bit inconsistent. So our goal is to bring more clarity to the space, and in doing so, demonstrate and provide a roadmap for the SEC when they are examining us on web scraping. They can kind of use these as guideposts and see what those industry norms would be. Moving on to privacy. So this is GDPR, CCPA. There's also a few other international and state-specific privacy regulations that are out there, but these are the main ones. So why are we talking about privacy? Well, of course, web scraping could potentially bring in some personal information in its data collection. But I think as a general rule, it's worth stating this, that buy-side firms, we really do avoid receiving any personal information in the data that we license. At the end of the day, what we're really trying to do is trade based on aggregated trends, not on the actions of specific individuals. So from a research perspective, personal information in a data set is superfluous at best, but could add unnecessary noise to a data set at worst. But at the end of the day, I think the research stack is not as concerned as legal is with personal information as a data set. And it really is a focus of legal and compliance professionals on the buy side to confirm that data has been de-identified or anonymized, really for two main reasons. I think first, the possession of personal information really subjects firms to a slew of logistical obligations. This really manifests, I think, mostly in consumer requests to us. So if we have personal information and somebody makes a request to delete or provide them with that information, it's an operational burden on us. And if we can avoid receiving any personal information, we can avoid all of those obligations. Second, and maybe more interesting, and tying this back to the insider trading claims that we discussed earlier, is that we know that the SEC is focusing more on privacy recently. And this is really interesting because it's not necessarily within their jurisdiction. So the fact that they're focusing on this is something that I think has really piqued a lot of our interest in the LNC world. And it may imply that they're circling around the possibility of bringing insider trading claim predicated on the possession of personal information that has not been obtained or distributed in strict compliance or adherence to relevant privacy regulations. So that's really why privacy comes into play. And when you're speaking to me or to Max, and we're really kind of digging in on the anonymization methodologies, this is really what we're trying to figure out, avoid the operational risk and avoid the potential regulatory risk. Moving on to electronic trespass, and I'm gonna go through these last two pretty quickly. And Max, feel free to jump in and add any color on any of these things. But for electronic trespass, really what this risk pertains to is having a hit rate that might be high enough to disrupt the functionality of a website. And the practical risk there is that a website operator, their website is now down. It might be running not at optimal speed or functionality, and you could potentially face litigation or claims from that website operator that you've superseded how much access you have to that website. This could also interact with reputational harm. If a buy-side firm or a data provider is hit with a lawsuit or some kind of claim from a website operator, that could very easily get into the headlines and result in all the reputational harm that we discussed earlier. And last but not least is copyright and CFAA. And these really pertain to IP infringement and hacking risks. So like electronic trespass, collecting and distributing copyrighted material without proper authorization may subject that data collector to an IP infringement claim, which could also result in that reputational harm.
Thanks, Danny, for taking a moment to go through each of these risks. I just wanted to add one sort of broad comment. I think all of these risks we're telling you about, these are the things that the web scraping guidelines are designed to protect against. So when Sarah comes on to tell you about some of the more technical aspects of the guidelines, just keep in mind that the reason for their existence is to protect against these very risks. One other point that maybe is a little bit in the weeds, but I think it's worth mentioning with regard to the GDPR and CCPA, an additional risk that we need to deal with is to the extent we receive that information, ideally we would like to just delete it immediately. But there may be regulatory reasons, particularly the books and records rules under the Investment Advisors Act, that may cause us to need to keep that data in some form. And that causes a lot of, as Danny said, logistical headaches. But with that, I think Danny gave a really good overview of all of these risks, and we'll get into some of them in a little bit more detail in future slides.
Thanks, Max. So as promised, we're going to get into the elements of insider trading with a little bit more granularity. I think this is important for data providers to see where we're coming from, because we do tend to have some pretty in-depth diligence calls with vendors, and I think to data providers that are new to this space or new to providing their data to the buy side, this comes as a little bit of a surprise. So I think understanding what goes into insider trading and what constitutes material non-public information, or MNPI, is really going to be beneficial both to the buy side and to data providers. So as mentioned, in order to sustain an insider trading claim, the SEC needs to prove that three elements are present: materiality, that the information is non-public, and that it was obtained in a breach. So when we talk about materiality, information is going to be deemed material if it would be substantially likely to influence the decision of a reasonable investor, if that investor had knowledge of the information. So I put air quotes around a couple of phrases there to demonstrate that it's not an objective standard. It is really fact-based. What is substantially likely to influence? What is a reasonable investor? It's something that's going to be really, really difficult to define in a vacuum, and it's going to be pretty fact specific. So what that usually means is that a particular scenario is going to be decided by a finder of fact, a jury or a judge, and it's not something that I think Max and I want to hang our hat on and saying that something is definitely going to be immaterial. So a few examples of things that are potentially material could be changes in management of a publicly traded company, M&A activity, public offerings, upcoming research or financial reports. Those could all be deemed to be material information. But like I said, there are a few instances in which we might be able to prove that something is immaterial, but it's not something that I think we typically want to rely on. Next is non-public, and I think this element causes a little bit of confusion. So information is generally considered to be non-public until it has been effectively communicated or otherwise made available to the marketplace. So what is public in the security law context is different than what I think the layperson would view as publicly available. And that distinction is really important. And it also makes things a little bit more complicated for us and a little bit more murky. How do we know when information has been effectively communicated to the marketplace and reflected in the stock price? Could you say that something that is web scraped, is that publicly available? Has that been communicated to the marketplace? I think there's some decent arguments to say yes, but there's no real case law and there's no precedent that we can really rely on to say that for sure. And I think that in the absence of that case law, in the absence of that certainty, most firms on the buy side are going to play it a little bit more conservatively and not necessarily view that information as public from a securities law perspective. You certainly could make arguments, like I said, and I think those arguments probably do have legs. But I think until we've seen that play out in the courts or in some type of enforcement action, we're going to play it a little bit more conservatively. Although I think firms have their discretion and their own risk tolerance and are able to make that determination on their own. I want to just maybe articulate this a little bit more with an example. So if we've seen this play out in the past, where if the price of a stock moves after a public announcement, it is often argued that as evidence that the information had not been made public prior to that announcement. So the fact that something is web scraped and that information is publicly available, but maybe it hasn't been announced by the company itself or widely broadcast, that might not be public information for securities law perspective. So it is something to keep in mind. So moving on to the next element, and I think this is where most firms are going to spend the most time. So you'll hear this word data provenance a lot in the space right now, and verifying data provenance. And that is really going to this breach element and trying to verify that there haven't been any breaches in the chain of title from where the data was created to any of the other parties that might be in the chain before it's received by the buy side. Now, traditionally, when we're talking about breach, a breach would be found if a fiduciary duty or a confidentiality obligation was breached. That was needed in order to sustain an insider trading claim on this element of breach. However, with the proliferation of technology and data, that standard has been broadened a bit by the SEC. So it's not just a fiduciary duty. It could be any information that has been misappropriated, obtained by deceptive means. And I think given this uncertainty, because we've only seen a handful of cases where the SEC has brought an insider trading claim for breach of something other than a fiduciary duty, there's only been a handful of these cases. So we're not sure where the contours are and where that breach element might, I guess the edges of that breach element are. So theoretically, a breach of online terms of service could rise to this level to meet this element of breach. Like I said earlier, breach of a privacy regulation could potentially reach this threshold of breach. whether or not that's true, I think we're still kind of waiting to see where the SEC is going to be able to prevail and where it might not, and that might further define the nuances of this element of breach. But I think for the most part, the conservative firms, which I think that Two Sigma and I think that PDT are probably on the conservative side, we are going to be digging into this as much as possible. And in these conversations that we have with our data providers, that's really why we're trying to get under the hood. We're not trying to understand how you're collecting the information so that we can go do it ourselves. We really are just trying to make sure that we have something documented that we can show the SEC that we've done our diligence, and to the best of our knowledge, there is no breach of online terms, there's no breach of privacy, there's no breach whatsoever. Max, I don't know if you wanted to add anything to that before we move on to the next slide.
No, nothing specific on this one. I think we're ready to tie some of these concepts together with the next slide.
Great.
So this is a case that we wanted to discuss. It's one that you may be familiar with already. It's HiQ versus LinkedIn. It's a fairly complicated case, and I'm not going to go over all of the procedural history or really dig into the facts that in depth. Instead, I'd like to use this case to discuss how we are thinking about certain concepts when it comes to considerations in web scraping. So at a very high level, it's important to know that HiQ's business was built on data collected from public LinkedIn profiles. So there was web scraping going on, but HiQ was not using any user logins or anything like that. It was going to the public profiles of LinkedIn users. And HiQ received a cease and desist notice from LinkedIn. And rather than wait to get sued, because it needed to continue to collect the data in order for its business to survive, it sued LinkedIn and alleged an interference, a tortious interference with contract claim. And LinkedIn primarily relied at the early stages of the litigation on a Computer Fraud and Abuse Act counterclaim or defense, basically saying that after having sent a cease and desist letter to HiQ, HiQ is accessing its computers without authorization. So the facts of the case sort of hung on this Computer Fraud and Abuse Act allegation. And the court said, and this is the Ninth Circuit Court of Appeals, so this is a court that states the law for a number of Western United States, but not for the entire country, obviously. It stated that when a computer network generally permits public access to its data, a user of that data will not, be accessing a computer without authorization under the Computer Fraud and Abuse Act. So this is good news for web scrapers and those who rely on web scrape data. There were some doubts as to whether accessing computers after having received a cease and desist, or perhaps after agreeing to certain terms of service, a number of different fact patterns, whether that would be computer fraud or hacking under the Computer Fraud and Abuse Act. And the reason this matters so much to Danny and I and the rest of the buy side is this does seem like the SEC hasn't stated a clear intention, but if someone were to, quote, hack a computer or do something that they shouldn't have under the Computer Fraud and Abuse Act, that does seem like something that might form a predicate for an insider trading claim. So while this is a good case, I think it's often overblown by trade media, news media. A lot of people treat this case as saying, okay, great, we now have legal license to go and web scrape whatever we want. The facts of the case are definitely much more narrow than that. And even if one were to assume that it states the law on Computer Fraud and Abuse Act claims, there's still plenty of other defenses that LinkedIn has, plenty of other legal risks, copyright, trespass to electronic trespass, as Danny went over earlier. Any of those could potentially be the predicate for an insider trading claim. All that said, the case is also up for review by the Supreme Court. And there's another case, the Van Buren case, which I won't get into, which also may, elucidate the law on web scraping. And it's entirely possible that the Supreme Court reverses this case or otherwise narrows it. I think the other thing to keep in mind is that this case focuses purely on public data. It doesn't really speak definitively on what happens if you go beyond a CAPTCHA, or what happens if you put in a login and password, whether that is your own login and password or that of a user of the website. So it is important to keep in mind that this case is not a panacea. Tracy, if you could move to the next slide. So this is one of 2 articles that we just want to show you that sort of stands for the proposition that the public is aware that their data is being collected by companies. In this case, it's geolocation data. Geolocation data does happen to be sort of a hot button issue right now. So this case, this article came out, I believe, in late 2018, and it shows, with some, alarming detail how closely you may be tracked depending on your, what applications you are using and your data location settings in those applications. One example is shown on the next slide. Users of the Weather Channel app, which I believe was bought by a large computer company, those users didn't realize, allegedly, that they were consenting to have their location shared even while the application wasn't open on their phone. They thought, allegedly, that they were downloading an application that would enable them to receive location dependent weather. But in fact, their data was being harvested for other additional uses, including advertising and as this article from the New York Times stated, to be sold to hedge funds. So these are some of the privacy issues that we are concerned with. They potentially can cause reputational issues. I'm sure no buy-side firm wants to see their name in an article like this saying, firm X is a user of this data. It's such creepy data, as Danny said, that could lead to redemptions or other reputational, legal, or regulatory harms. And if we can move to the next slide.
Yeah, so I'll take it from here. Thanks, Max. So going back to reputational risk, and I think the Weather Channel case is actually really interesting because they showed up in this New York Times article that damaged a little bit of their reputation, but it also led to a lawsuit out in California. So it shows that reputational risk is not in a vacuum. It does have some real world consequences, not only to the goodwill of your brand, it could also lead to litigation or other commercial consequences. I think a really good recent example of reputational risk and the real world consequences it could have is the Cambridge Analytica issue that came up. I think it was last year, it might have been the year before. And the resulting fallout that the Facebook stock took. Many of us, I think, probably viewed Mark Zuckerberg's resulting Senate Judiciary hearing. And despite the fact that Facebook didn't actually do anything that was against the law per se in providing a professor with access to their database, that professor's onward sharing of that information to Cambridge Analytica really had an impact on Cambridge Analytica, who went bankrupt after this scandal. But like I said, it also had a huge impact on Facebook's stock price. So despite whether we agree with it or not, the buy-side firms really aren't regarded in a positive light by the public. So any perceived misstep is great media fodder. And like Max said, I don't want my firm's name in any negative media coverage, and nor does he. So we really do want to be profitable, but we need to make sure that we're doing it ethically to avoid any type of negative press that are going to have these commercial consequences. Tracy, can we move on to the next slide, please? Thank you.
So just really to wrap up this section of the webinar, we need standards in order to guide the behavior of the buy side and of data collectors. Danny and I want to avoid all of these legal, regulatory, and reputational risks. Web data collectors, they want to be able to act in a way that allows them to remain competitive, to get all of the data that they can in a fair way, so that they can have products that can be used by the industry. And as Danny mentioned earlier, these guidelines are designed to sort of, get around the legal and regulatory uncertainty that we're currently in. We're trying to sort of self-govern in a way, provide guidance that allows collectors to figure out the appropriate policies and how they're going to go about their web data collection activities. And with that, I'm going to turn it back over to Liz for our next poll, I believe.
Terrific. Thank you, Max and Danny, for unpacking, which is quite a complex landscape of legal and compliance questions for data vendors as well as financial firms. While Sarah is getting ready, why don't we go to another poll here? And this one is around use cases. What is web scrape data used for? Typically in finance, we think it's used for investment selection, and there are other use cases. So curious to see how you all are using web scrape data. Is it for investment selection, lead generation, recruiting and hiring, or all of the above? And if you're not using web scrape data, you can certainly take a breather and sit this one out. While the results are coming in, Sarah will tee you up for our next talk. Okay, let's go ahead and look at the results. All of the above. Okay, so quite interesting. All of the above for most of our audience, almost 60% of the audience using web scrape data across the board on use cases. Okay, well, thank you for that. And with that backdrop, let's hear from Sarah for your insights from the perspective of a web data collection provider. Take it away, Sarah.
So thank you, Elizabeth. And for any of you that are doing web data collection now, you know that it's a multi-structured and rapidly changing data source. You're probably dealing with hundreds or thousands or tens of thousands of these. And you're probably wondering, how exactly I'm going to walk you through this, managing this data collection operation and incorporating all the risk mitigation strategies to deal with the legal jeopardy that comes with this space, being in the cutting edge of our industry, which is not quite regulated. You know how difficult the operation is, so I'm sure you're probably scratching your heads and wondering how to manage all these risks. Can we go to the next slide? So Sequentum sells both software licenses and bespoke web data collections subscription services. We have over 5,000 customers, including 20 government agencies and some of the largest hedge funds and financial institutions. We're backed by WorldQuant Ventures. And as a company, we are, and a product development company at that, we are very focused on driving efficiency in web data collection. We've been at it for 10 years. And we really look at it across 3 lines, right? It's driving efficiency in your labor costs, driving efficiency in your infrastructure costs, and of course, minimizing your legal risk from operating in this loosely regulated space. So the way we define our risk mitigation strategy is sort of similar to how most firms design their security, technical security mitigation strategies, right? It's people, process, and tools, right? If you provide the guidelines for how people need to operate, you educate them on a regular basis, and then you provide a detailed process which is quantifiable and measurable and auditable, and you provide tools that make it easy to conform to the process and the rules, the guidelines, in a repeatable way, reusable, scalable, easy to use tools, then that gets you a long way to mitigating your risk. And if you build, so what we aim to do from mitigating the legal risk strategy, and we recommend that you do the same, whether or not you use our software. Basically, you want to document, you want to make sure you document what your operating guidelines are, and you want to have a way, an auditable, transparent way to demonstrate that you're actually conforming to those guidelines. So what we've done as a company, and certainly we had to think long and hard about this when we engaged in bespoke services contracts with SEC regulated funds. We broke down our operating guidelines as a schedule to our contracts and listed out each of the types of operational behaviors that we see as bringing risk, potentially bringing risk. And we break them all out into a checklist, and we allow our services customers, and we recommend you do the same, to specify exactly what their risk tolerance is and what behaviors they're willing to do and not willing to do. And then we use our platform to enforce and to provide an audit trail and transparency into exactly how that data operation is running. We also provide approvals, an explicit approval process, because some teams do require that. So let's go to the next slide. So we basically have a complete framework for managing the data operation and all these reusable building blocks that come with that framework, right? There's point and click, low code ways to very quickly generate what we call an intelligent agent. What we do is we architect the framework in such a way that every little change is done in a discrete place. And what this does is it makes it very nimble, very rapid to get new agents out there, very quick to respond to changes in those upstream web sources, but also because we're managing all the version tracking, all the servers, all the deployment, all the scheduling, that quality monitoring, alerts, alarms, tickets, because we're managing everything centrally, we can provide that full audit trail. And we also document, the system automatically documents what's in an agent, what exactly that agent is doing. So when it comes to your operating guidelines, you can have a team that can actually, who's non-technical, they don't have to be data engineers, they can see into the data operation and see that folks are complying, and they can implement a governance process that works for your business, and it can be customized based on what risks the business is willing to take. So for example, let's say, and not everyone is the same, right? Terms of service, terms of use on a website, right? Some companies consider the terms of service to be non-binding and to be, sort of optional. If there's no click wrap that forces you to accept those terms, to affirmatively accept those terms, then many firms don't consider that to be legally binding. If you've never accepted the terms, why would they apply to you? Not everyone feels this way, but if you operationally have to support affirmative acceptance and tracking of those terms, well, then you better have something built into your operation that checks those terms, checks for any changes in those terms over time, automatically notifies and turns off any agents for a site where the new terms, changed, modified terms have not yet been explicitly approved by that lawyer. And that's something that can be baked into the framework and baked into your operation very easily. Proxies. So we provide centralized management of proxies. You use, if you're in our business, you'll definitely know what proxies are. You'll have all kinds of different providers that provide different types of proxies to route your requests one way or another so that you can pull, data that is only shown to specific types of proxies, for example. But there's a lot of considerations that we've published now under the Alt Data Council on the FISD website, and I won't go into every single one, governing the use of proxies, and specifically for the finance industry, making sure that you don't mask your identity, because that's a big risk in this area, and most of our customers in the financial vertical do not want to make sure that at no point is the identity being masked those web requests to those websites. And they want to make sure that if there's a complaint from the website, that you will be able to be contacted. So, we provide centralized management. It's very clear what proxy providers you're using, what proxies are in use and have been used. We have very detailed logging. And then you can also see in the agent itself how those requests are made. If there's, really advanced anonymization, which our platform can do, but you don't need to use that. You can actually affirmatively say, this request is coming from Sequentum. So you can clearly make sure that you're not masking identity, make sure that any complaint or cease and desist that might come from that website really reaches you. So that's something that to keep in mind. Volume considerations are another really big one. We have rate limits in our software. We have all kinds of fine-grained controls about exactly how you make your requests and what delays might happen between requests. This is really important because if you cause a website to drive up their costs by making too many hits, for example, at midnight, you make 100,000 requests to all these web pages, you might cause that website to spin up tons of servers, which is a big expense. They could come after you for that, right? So we have rate limits and we have all kinds of controls that are easy to see and comprehend by a non-technical ops manager or compliance user. And our system has specialized users and permissions for each of the types of users you might have, right? You don't want a compliance user going in and changing your schedule or making edits to your collection agent. So we manage all that for you. Robots.txt, if your compliance team wants you to follow Robots.txt, it's an extremely simple setting to follow it 100% of the time, or to log a warning, or to always ignore, right? And again, there's this spectrum of risk tolerance. Everyone is in a different place. Most people, I'd say, don't think Robots.txt is binding, just like terms of service. Some firms still do have concerns about it. So it's just a setting, it's a configuration, very simple and easy to see. For other things that are a little more complicated, like privacy, Sequentum as a company doesn't collect PII, and we don't, we just won't do that. Somebody mentioned, LinkedIn data, anything that's behind a login, we would never do that. But we also provide quite transparent data validation. So if you're collecting data from a public website and you don't expect to be getting anyone's email address or phone number, let's say it's seller information for a used car site, and you're really only interested in dealer information, you can put in some regular expression in the data validation to make sure that you're not pulling any individual emails or phone numbers, of individual sellers. You can put extra regular expressions in there, which are, again, very easy for any sort of compliance user or ops manager to see that those controls and those checks are in place. And then you can configure rules to automatically halt data collection if those validations are not passing. CAPTCHA is another big one, right? They talked about technological barriers. We're going to release some guidance on this soon. It's been very interesting and very, very in-depth discussion. In our system, if your lawyers approve the use of CAPTCHA, then you can easily see it's a template command in our framework. So you can see it in the agent documentation. It's either there or it's not. One other thing I want to mention is approvals. So when you're doing web data collection, you have to respond very, very quickly to all kinds of changes. You need to make those changes, change the way that your agent is working against these rapidly changing web sources that you're working with. You need to get it up into, tested, deployed. all of that good stuff. But when you need it, when you also need an approval process, you know, you have a framework. What we've done is we've provided the ability for a compliance user to actually approve an agent before it can be scheduled in production. And this really, you know, provides what we think is the best practice for mitigating legal risks that come with web scraping, and for giving you, you know, some framework to manage not just the whole web data collection, right, but the risks that come along with it. And it should, right, with all these reusable modular building blocks of automation and all the audit trail and logging and permissions built in, it should also provide a nimble framework to adjust, that can adjust as your mitigation strategy changes over time. That's it.
Terrific. Thank you, Sarah. I mean, it's obviously, there's so much diligence that's applied to ensure both website owners' data is treated with care and your customer requirements are met. It's a very delicate balancing act, isn't it? Okay. Now we're going to open up our final speaker segment as we're approaching the top of the hour. We'll enter this segment with one more poll. Which of the considerations, the web data collection considerations, is the most difficult to apply in practice? Terms of service, volume considerations, CAPTCHA, robots.txt. And I realize there are at least 5 or 6 other considerations that we're working on, but kind of wanted to test, take the temperature across this set of 4. So let us know, both buy side and data vendors, what you think is the most difficult to implement in practice. Let's take a look at the results. Terms of service. Okay, very, very interesting. I was going to handicap CAPTCHA as the most difficult, but terms of service. And with that, let's turn over to Max and Danny to weigh in on the practical application of the considerations for their views. Over to you both.
Thanks, Liz. So up here on the screen, we have an excerpt from the FISD standardized data provider due diligence questionnaire. And we specifically have a couple of the questions that Danny and I would ask a vendor who's providing a data set that is collected by web scraping, or that we would ask someone like Sarah if we were engaging her to perform a data collection operation. So we get into the nitty gritty questions of, do you analyze terms and conditions? Do you, have rate limits in place, or can you put them in place in order to align yourselves with our risk tolerance? And the way this ends up in practice is Danny or I or one of our colleagues will get on the phone with a vendor and go through in some, sometimes a fairly high level of detail, how they go about the collection of the data. And just to reiterate, it's not because we want to replicate their process and collect the data ourselves. All of this data is, if not public under the securities laws, it's certainly publicly available. And if we wanted to do that, we would just go ahead and do it. It's really because we are experts in taking the data and forming investment decisions or using it for other purposes. We only need to ask these questions because we need to guard ourselves against these various legal and regulatory risks. And this due diligence questionnaire and our compliance calls with vendors is our primary means to do that. And I'll hand it over to Danny to talk a little bit more about the guidelines.
Thanks, Max. So I think as we've all touched on a little bit, the goal of these considerations that Sarah went through is really to provide some clarity around ethical web scraping practices. This is in the absence of statutes or case law that can really adequately address these legal nuances that we covered. Now, when we developed these considerations, we used our industry experience and applied relevant case law to the extent there was some to the various components that constitute web scraping. That said, in the absence of clear and precedential case law on these issues, the considerations that we've discussed today are just that. They're considerations. They're not best practices. they're not requirements, and they have not been approved by lawmakers or by regulators. So every data provider on the call and every buy-side firm should really assess each consideration themselves and apply or adjust them in accordance with their own business practices and risk tolerance. But I think what really is most important for the buy-side firms is to create an onboarding process that is documented, along with their rationale for the choices that they made, whether they want to follow the considerations or augment them in specific ways, and then to apply those processes and considerations consistently across data vendors and data sets. That's really where the SEC, I think, is going to focus. And Elizabeth, back over to you.
Sure. Yeah. Thank you. Thank you for that. I mean, obviously, taking the framework of the considerations and the legal landscape and the regulators taking a look at alternative data. This is obviously a very important topic to unpack. Before we wrap, and I hand control back over to Tracy, could you share with us briefly an example? And this is I am posing to each of our panelists. Could you share with us an example of where you've needed to turn away a data vendor, and obviously without naming names, but the reasons why you needed to turn away the vendor?
So I'm happy to respond first, and I'll offer two quick examples. One data vendor we didn't have to turn away, but we did need to work with them to alter their standard product in order to meet some of our requirements around privacy. And then we did have one other vendor who, you know, I don't think I'll ever forget what they said, but on a phone call, I had asked some questions about their scraping practices, and the CEO of this company told me that while their practices weren't illegal, they were probably unethical. And I very shortly after that thanked him for his time and wrote the memo describing why we wouldn't be doing business with that vendor.
Thank you. How about you, Danny and Sarah?
Yeah, sure. So I think Max makes a really good point, that oftentimes we're able to augment the product that's offered. So in Sequentum's case, we might not go with the standard product, we might go with the bespoke product to handle specific business requirements or specific legal requirements, although it sounds like Sequentum's product is able to turn on and toggle all these different things on and off. So that's really great to have. Much like Max, I think the cases where we've rejected a particular data set is because numerous considerations that we've outlined were not able to be fulfilled. Maybe they weren't able to respond to cease and desist. Maybe they weren't able to remove personal information. Maybe they were clicking through terms that prohibited web scraping. So it's all of those things combined that really get us a little bit nervous on the LNC side.
Thank you, Sarah.
The main problem that we run into is either they want us to slam the site too hard, like you know, pull down all of eBay every hour, or they'll want us to log in and collect data behind a fake account, and we can't do either of those. Yeah.
Understood. Thank you. We are out of time, and you know, there's enough content here really to have a half-day workshop at least. So thank you for your time, panelists. And a takeaway for me is it's really important to understand where the guardrails are, and the web data collection considerations help us do that across the industry. So over to you, Tracy, for closeout.
Thanks, Elizabeth. And again, thank you, amazing panelists. I'm just going to do a very, very quick close, but just take 10 more seconds to say, honestly, I don't think we could get any better than the speakers that we've had today. You guys are amazing. Thank you for your time today, and also for the dedication to standards creation. I think I speak for the audience when I say we couldn't be more grateful. So on that note, just a few bits. If you enjoyed this, there's a bunch of other activities coming up, and indeed we will be delving into some of the more complex web scraping topics that were referenced here. So I hope you can join us for any of these virtual activities, and we'll be in touch on those soon. If you love this, which I'm sure you did, please fill out a post-event survey. It helps us craft our future programming. I'd love to thank our sponsor, S&P Global Market Intelligence, our global sponsors, SIBO, CME, FactSet, and SIX, without whom we could not have put on this amazing content. And again, thank you so much for joining. Delighted to have you and hope to see you again soon. Everybody have a great rest of your day. Take care all.